For this video, we are going to discuss the justifying circumstance of self-defense. This is based on Article 11, Paragraph 1 of the Revised Penal Code as amended. Article 11, Paragraph 1 of the Revised Penal Code states that a person who acts in defense of his person or rights does not incur any criminal liability provided that the following requisites concur. First requisite is that there must be unlawful aggression. Second, there must be a reasonable necessity of the means employed to prevent or repel such unlawful aggression. And third, there must be no or lack of sufficient provocation on the part of the person defending himself. Now, before we discuss each of those requisites, allow me to first discuss to you the meaning of certain phrases as what we have already read in the first slide. I am talking about the phrase, a person who acts in defense of his person or rights. This phrase does not only refer to defense of life. I am referring to physical self-defense per se, but also includes defense of the person's rights, which are defense of chastity, defense of property, and defense of honor or reputation. The person himself whose life, chastity, property, or honor is being attacked must be the same person who must repel such aggression on his life, on his chastity, on his property, or on his honor. The other phrase that I would like to discuss is this phrase. The meaning of the phrase does not incur any criminal liability. This simply means that the justifying circumstances under Article 11, if proven, will absolve the accused from criminal liability. For example, X killed Y. During trial, X was able to prove self-defense, for which reason he was acquitted. Here, even if X indeed killed Y, he will not be penalized for the consequences of his act, because his act will not be considered a crime, and since there is no crime, X will not be considered a criminal. X will not be civilly liable either. Therefore, when justifying circumstances such as self-defense are proven, the accused will not be both criminally and civilly liable. In that same example, what if X gets convicted of murder? What will be his liability? Article 100 of the Revised Penal Code states that every person criminally liable for a felony is also civilly liable. Therefore, X, if convicted, will be criminally liable, which means that he will suffer the penalty of imprisonment. And in the case of murder, he will suffer the penalty of reclusion perpetua, which means imprisonment ranging from 20 years and 1 day to 40 years. And since Article 100 states that he will also be civilly liable, X will be civilly liable, which means that he will be ordered by the court to pay actual, moral, exemplary damages, etc., as the case may be. Now, let's discuss the first requisite of self-defense, which is unlawful aggression. Ano ba itong unlawful aggression? Unlawful aggression is a physical movement directed against another person that puts in danger his or her life and safety. And the danger here may be actual or imminent, as I will be expounding later on. There are two kinds of unlawful aggression. The first kind is called actual or material unlawful aggression. And the second kind is called imminent unlawful aggression. What is actual or material unlawful aggression? Actual or material unlawful aggression is an attack with physical force or with a weapon. It is an offensive act that positively determines the intent of the aggressor to cause the injury. Here are some examples. First example, X is stabbing or hacking Y with the use of a bladed weapon. Second example, X is in the act of punching or delivering fist blows to Y. Third example, X shoots at Y but missed, but continues to shoot at Y. Here, the danger, take note, is no longer imminent or impending, but is actually happening. On the other hand, imminent unlawful aggression is also an attack with physical force or with a weapon that is impending or at the point of happening. Take note that imminent unlawful aggression must not consist in a mere threatening attitude, nor must it be merely imaginary, but must be offensive and positively strong. Here are some examples. X aimed a revolver at Y as if to shoot. Another example, X unsheathed his bolo and made a motion as if to stab Y. Third example, X got hold of an iron bar and made a motion as if to strike Y. Here, the person defending himself, Y, doesn't have to wait for X to actually shoot or to stab or to strike him before he can repel or prevent the aggression. Such act of the aggressor, X, has already put Y's life in danger of death or injury. This is the reason why, even if the aggression is not yet actually happening, the person defending himself can already prevent such aggression. Here is another example. X was shouting at Y saying, "I will kill you," and then pressed his right hand to his hip where a revolver was holstered. Question, is it unlawful aggression? The answer is no, because X here merely exhibited a threatening or intimidating attitude. It has not reached the point of imminent unlawful aggression because it is not yet clear at this stage whether X will actually remove his gun from his hip and aim it at Y as if to shoot. Take note that whether the aggression is actual or imminent, the same must be unlawful. Why? Because if the aggression is lawful, the claim of self-defense cannot be appreciated. Question, what are then these instances of lawful aggression? The first instance of lawful aggression comes within the concept of fulfillment of duty, which is also a justifying circumstance. Here, a policeman in the performance of duty is justified in using such force as is reasonably necessary to secure and detain the offender, or overcome his resistance, or prevent his escape, or recapture him if he escapes, and protect himself from bodily harm. In case injury or death results from the policeman's exercise of such force, the policeman could be justified in inflicting the injury or causing the death of the offender if the policeman had used necessary force. Now, since a policeman's duty requires him to overcome the offender, the force exerted by the said policeman may therefore differ from that which ordinarily may be offered in self-defense. Take note of that. However, a policeman is never justified in using unnecessary force or in treating the offender with wanton violence or in resorting to dangerous means when the arrest could be effected otherwise. This is the ruling of the Supreme Court in Cabanlig versus Sandigan Bayan. Here are some examples of where fulfillment of duty is considered a lawful aggression. In People versus De Lima, a policeman was looking for a fugitive who had several days earlier escaped from prison. When the policeman found the said fugitive, the fugitive was armed with a pointed piece of bamboo in the shape of a lance. The policeman then demanded the surrender of the fugitive. The fugitive, however, instead of surrendering, lunged at the policeman with his bamboo lance. The policeman dodged the lance and fired his revolver at the said fugitive. The policeman missed. The fugitive ran away still holding the bamboo lance. The policeman pursued the fugitive and again fired his revolver, this time hitting and killing the said fugitive. The court acquitted the policeman on the ground that the killing was done in the fulfillment of duty. Here it appears that the policeman acting in the fulfillment of duty is the aggressor, but his aggression is not unlawful, it being necessary to fulfill his duty as a police officer. However, in the case of People versus Lagata, a jail guard shot to death a prisoner whom he thought was attempting to escape. The court convicted the jail guard of homicide because the facts later on showed that the prisoner was not at all trying to escape. The court declared that the jail guard could only fire at the prisoner in self-defense or if absolutely necessary to avoid the prisoner's escape. Another instance of a lawful aggression is when the aggression is in the lawful exercise of a right. Under Article 429 of the New Civil Code, the owner or lawful possessor of a thing has the right to exclude any person from the enjoyment and disposal of his property. For this purpose, he may use such force as may be reasonably necessary to repel or prevent an actual or threatened unlawful physical invasion or usurpation of his property. Hence, a person may use such force or violence to protect his property, and if in protecting his property, such person uses force to prevent its being taken by another, the owner of the property is not considered an unlawful aggressor because he is merely exercising his right. For example, X, a robber, barged into Y's garage and tried to steal his motorcycle. Y shouted at X to stop, but the latter ignored his warning. Just as X was about to go out of the garage, Y fired his gun at X, hitting one of his legs for the purpose of immobilizing him. Here is another example which differs from the first example I gave a while ago. X, the owner of a cell phone shop, saw Y carting away several cell phones on display at his shop. X, without warning, then took his gun and shot Y to death. Question: is the aggression on the part of X lawful? The answer to this is no. Because if the aggression by Y is on the property only, as in this example, meaning there was no corresponding attack on the person of X, then killing Y will be unlawful. While it is true that Article 429 of the New Civil Code justifies the act of the owner of a thing in using such force as is necessary to protect his property rights, still such force must not be to the extent of taking the robber's life unless there is a like danger posed on the person or on the life of the owner himself. The value of the property, take note, can never equal the value of life. Another instance of lawful aggression is in the case of a husband who assaults his wife and her paramour because he caught them in the act of having sexual intercourse. In other words, the paramour cannot invoke, as well as the wife, cannot invoke self-defense in case he gets caught in the act of having sexual intercourse with the wife of the husband who was assaulting him. For example, X, the husband, surprised his wife and her paramour in the act of sexual intercourse. X then lunged at the paramour by attempting to stab him with a kitchen knife. The paramour, however, got hold of a chair and struck it on X's head, killing him. Here, the assault by X, the husband, is considered lawful because X, who was deceived and offended, was only protecting his honor and rights as a husband. This is so because had the husband killed his wife and her paramour, this would be an absolutory cause that would exempt the husband from criminal liability for parricide as provided for in Article 247 of the Revised Penal Code. Question: how important is unlawful aggression as an element of self-defense? Answer: without unlawful aggression, there is nothing to prevent or repel. Consequently, there can be no self-defense because there is nothing to defend oneself from an actual or impending harm. Here are some of the instances where the act is not yet considered unlawful aggression. First instance, the victim hurling insulting words no matter how objectionable they are. Second instance, the victim making a mere push or show. Third instance, the victim merely shouting at the accused saying, "I will kill you," and then pressing his right hand to his hip where a gun was holstered. Fourth instance, the victim and the accused agreeing to fight. Fifth instance, the accused voluntarily joining a fight when he did not have to do so. Or when the aggression has ceased to exist, as when the aggressor runs away or retreats. To repeat, in all of these instances, hindi pa ito kinoconsider na unlawful aggression. Now, since hindi pa ito kinoconsider na unlawful aggression, pag yung person, let's say, the person to whom the insulting words were directed, assaults the person hurling such insults, he cannot later on invoke the justifying circumstance of self-defense because there is yet no unlawful aggression at this stage. Before we proceed to the second requisite, let us first answer this important question. How is unlawful aggression manifested in defense of a person's other rights? I am talking about a person's defense of his or her chastity, defense of property, and defense of honor or reputation. Here are some examples. In the case of defense of chastity, the first example is X embracing Y and mashing her breasts and then throwing her to the ground for the purpose of raping her constitutes an attack upon her chastity. This is what? An example of unlawful aggression in the crime of rape or attempted rape, as the case may be, such that the victim here is justified or has the right in killing the aggressor. Second example, still in defense of chastity, X placing his hand on Y's thigh for the purpose of committing lascivious acts on her likewise constitutes an attack on her chastity. This is what? The unlawful aggression in the crime of acts of lasciviousness. The act of the aggressor in placing his hand on the victim's thigh. This gives the victim the right to repel or prevent such aggression. How? Not by killing the aggressor, because that is too much, but the victim here could probably hold the hand of the aggressor to prevent the aggressor from further touching her, or the victim can probably slap the aggressor and move away. That is the kind of defense that the victim can make in this kind of situation. In the case of defense of property, I have already pointed this out in the earlier slides. Let me give you more or less the same example, although in a different scenario. X snatched the wallet of Y and ran away. To prevent X from escaping, Y shot X, resulting in the latter's death. Now, if the aggression is on the property only, and there is no corresponding aggression on the owner or possessor of the said property, like what I said in the previous slides, defense is proper, yes, but it should not be to the extent of killing the aggressor. Why? Because the value of life is much higher than the value of property. Or otherwise stated, the value of property can never equal the value of life. In the case of defense of honor or reputation, let me give you this example. X posted on Facebook a statement calling Y a mistress for having an affair with Z's husband. This is an unlawful aggression on the honor and reputation of Y, which justifies Y to answer the malicious imputation also on Facebook or in any other social media platform. Y can even go to the extent of stating that X once had an affair with her boss. I am talking about fighting libel with libel or slander with slander. As I said, slander may be a necessary means to repel slander. Take note, however, that it must only be to the extent necessary to redeem the honor of the defender against the defamatory remarks. Because the purpose of self-defense in libel is merely to repair, minimize, or remove the effect of the damage caused to the person libeled, but it does not license the person libeled to utter blow-for-blow, scurrilous language in return for what he or she received. Once the defendant hits back with equal or more scurrilous remarks which are already unnecessary for his or her defense, then the retaliation becomes an independent act for which the defendant may be held criminally liable. So dapat tamang-tama lang yung slander na ibabato rin niya against the person who slandered or libeled him or her. Like what I said, slander can be a necessary means to repel slander, but it must only be to the extent necessary to redeem the honor of the defender against the said defamatory remarks. Second requisite, reasonable necessity of the means employed to prevent or repel the aggression. To repeat, without the element of unlawful aggression, this second element or requisite cannot arise. There is nothing to prevent or repel when there is no unlawful aggression. Now, the factors to be considered in determining the reasonable necessity of the means employed are necessity of the course of action taken and necessity of the means used. Now, in the case of necessity of the course of action taken, this refers to the circumstances surrounding the aggression. And with respect to necessity of the means used, this refers to a consideration of whether or not the aggressor was armed. This is also a consideration of the nature and quality of the weapon used by the person defending himself and the physical conditions and sizes of both the aggressor and the person defending himself. Here are some examples of necessity of course of action. First example, if there was no unlawful aggression, then there is nothing to repel, as when X merely uttered insulting remarks at Y. Another example, if the unlawful aggression had ceased, there was unlawful aggression at first, but it had already ceased or stopped, as when the aggressor had already run away, then there is no more need to assault the aggressor. Hindi na ho justified kasi wala na hong unlawful aggression. Third example, when the aggression was made in a dark or in a not so well lighted place, the accused is justified in shooting the victim who suddenly held him from behind and attempted to wrestle possession of the said gun. Here, the accused or the person defending himself is justified because what? Why? There is a necessity of such a course of action. Alangan namang mag-antay pa siya na babarilin siya. Diba? As what you can see in the example, the victim had already held the accused from behind and was already attempting to take possession of the gun from him. So in that situation, the accused had no other recourse but to shoot the victim, and even if he shot the victim and killed the victim in the process, he will be justified in doing so. Another example, when the victim has been disarmed, it is no longer necessary for the accused to continue the assault. Kasi wala na hong unlawful aggression. Na-disarm na nga eh. Another example, when the victim had been injured and could no longer continue his unlawful aggression, then there is nothing more to repel. Baldado na nga eh. Hindi na nga makapag-assault dahil na-injured na, then the accused or the person defending himself is no longer justified in retaliating or in assaulting the victim who earlier attacked him. Another example, when the victim, though armed with a bolo, did not attempt to stab the accused but only pushed or shoved him to the ground, there was no necessity on the part of the accused to strike the head of the victim with the use of a bamboo pole, as he was not in any real danger of his life. There is no necessity of a course of action that would justify killing the victim. Another example, when the aggression is so sudden that there is no time left to the one making a defense to determine what course of action to take, as when the victim is about to stab the accused. Here are some examples with respect to necessity of the means used. The first thing to consider in evaluating the necessity of the means used is whether or not the aggressor was armed. Now, as to whether or not the aggressor was armed, when a person is attacked with fist blows only, then there was no reasonable necessity to use a knife and inflict upon the aggressor a mortal wound that would cause his death. While there is here a necessity to act by using fist blows also, there was no reasonable necessity to stab the aggressor, let's say on the chest or on his stomach. Another example, when the aggressor merely touched the woman's thighs in a place where there are many people, there is no reasonable necessity to shoot the aggressor, as there would not be any danger to her honor or chastity. Like what I said, probably the accused or the person defending himself could only slap the aggressor but not kill him, because that is no longer reasonable. Another consideration is as to the nature and quality of the weapon used. Now, the person defending himself is not expected in an emergency situation to select a less deadly weapon, as when the aggressor is about to strike him with an iron bar, for which reason he had to fire his gun. Another consideration or factor I am talking about as to the number of aggressors or as to the physical conditions and sizes of both the aggressor and the person defending himself. Now, if the aggressor attacking with fist blows was younger and bigger than the person defending himself who was armed with a bolo, or if the person defending himself was being attacked with fist blows by several aggressors, coupled with the fact that the aggressor or aggressors, if allowed to continue with their assault, would put the life of the person defending himself in danger, then the latter is justified in using a knife or even a gun in repelling the aggression. Now, what is the rule if the person defending himself is a policeman or a law enforcer? For example, X, a policeman who was armed with both a batuta and a gun, was trying to arrest Y, whom he saw stabbing Z. X shouted at Y to surrender, but instead of surrendering to X, Y instead charged at X, who was standing at a distance. X shot Y. Question: is X justified in shooting Y? The answer is yes, because a policeman in the performance of duty represents the law which he must uphold. While the law on self-defense allows a private individual to prevent or repel the aggression, the duty of a policeman requires him to overcome his opponent. Now, the fact that a policeman who was armed with a gun and a batuta should have used his batuta instead is of no moment, since a policeman is not required to afford a person attacking him the opportunity for a fair and equal struggle. Police nga siya eh. His duty is to overcome the aggression. The third requisite of self-defense is lack of sufficient provocation on the part of the person defending himself. For this third element or requisite to be present, the person defending himself must not have given cause for the aggression. That is, he must not sufficiently provoke the aggressor. Hence, this third requisite is present when there was no provocation at all. For example, X, who was just walking his way towards home, was suddenly approached and stabbed by Y. Wala talagang provocation dito, naglalakad lang nga eh. Tapos bigla siyang sinunggaban ng assailant or ng aggressor. Another instance is when even if there was provocation, it was not sufficient. For example, X told Y, "When are you going to pay the 20,000 pesos you borrowed from me? It's been 5 months." Now, let's say this statement angered and provoked Y, as it was heard by his friends who were with Y at the time. As a result, Y attacked X. Here, even if X's remark provoked Y, the provocation is not considered sufficient. X had the right to demand payment, and that the exercise of a right cannot give rise to sufficient provocation. Another instance is when even if the provocation was sufficient provocation but it was not given by the person defending himself. So, nasatisfy pa rin yung third element, no? Lack of sufficient provocation on the part of the person defending himself. For example, X provoked Y by insulting him and challenging him to a fight. Instead of assaulting X, who was the one who gave the provocation, Y instead attacked Z, who was merely accompanying X. The fourth and final instance is when even if the provocation was given by the person defending himself, but it was not proximate and immediate to the act of aggression. For example, X hurled insulting and humiliating remarks at Y. A week later, when Y and X met again, Y this time assaulted X. Now, while it is true that X sufficiently provoked Y the week before, the provocation is no longer considered proximate and immediate to the latter's unlawful aggression. So those are the four instances where the third element is present. And the third element is the lack of sufficient provocation on the part of the person defending himself. Last and final question. What constitutes sufficient provocation? It should be enough to steer the person provoked to commit an act of aggression. Let's go through some examples. X challenges Y to come out of the house and engage in a fist fight with him and prove who is the better man. Another is when X utters or hurls insults or imputes to Y the utterance of vulgar language. That also is enough to constitute sufficient provocation. Another is when X tried to forcibly kiss and touch the sister of Y. In all of the above instances, there is no complete self-defense because of the absence of the third requisite. To repeat, what are these three requisites of self-defense? There must be unlawful aggression. Without unlawful aggression, there can be no self-defense. The first requisite is actually the most important requisite of self-defense. Second requisite, there must be a reasonable necessity of the means employed to prevent or repel the aggression. To prevent the imminent unlawful aggression and to repel the actual unlawful aggression. And the third and final requisite of self-defense is the lack of sufficient provocation on the part of the person defending himself.